This is Medical Device Legal News. Today is November 15th, 2023. I'm Sam Bernstein. On November 13th, Brett Weiner and Valerie DeSalvo pled guilty to charges of conspiracy to pay kickbacks for their role in a durable medical equipment fraud scheme involving buying and selling fake doctor's orders through their company, Laboratory Marketing Services, LLC. Weiner and DeSalvo allegedly solicited and received kickbacks in exchange for durable medical equipment leads consisting of Medicare beneficiary information, and bought and sold signed doctor's orders, many of which were fraudulent and forged. In a similar durable medical equipment case on October 31st, Chintan Anjaria pled guilty to conspiracy to violate the federal anti-kickback statute and conspiracy to commit healthcare fraud in connection with a kickback and bribery scheme involving orthotic brace supply companies, telemedicine companies, and testing laboratories. Anjaria's India-based company would allegedly call Medicare beneficiaries and pressure them to accept orthotic braces and cancel genetic tests that they did not need. Anjaria and his company then allegedly paid kickbacks to telemedicine companies to obtain doctor's orders for these tests, and then allegedly steered the orders to suppliers and laboratories in the US with which they had a kickback arrangement. The laboratory and supplier would then submit claims to Medicare and other payers and pay a portion of the proceeds to Anjaria and his company. Anjaria faces up to 15 years in prison and a fine of up to $500,000 for twice the gain or loss from the offense. In another recent durable medical equipment fraud scheme, on October 26, Julian Laddie pled guilty to conspiracy to fraud Medicare, Medicaid, and TRICARE in connection with a back and knee brace fraud scheme. Laddie allegedly obtained personally identifiable information of Medicare beneficiaries and then paid doctors to sign prescriptions for braces they did not need, and then billed for the braces through his company, Beach Medical Suppliers, LLC. These cases reflect the DOJ's and FBI's continued focus on fraud enforcement in the durable medical equipment space. On November 6th, the HHS Office of Inspector General issued extensive general compliance program guidance. Similar to the OIG's prior compliance program guidance for pharmaceutical manufacturers, which also applies to medical device manufacturers, compliance with the general compliance program guidance is voluntary. Beginning in 2024, the OIG will begin publishing and updating industry-specific compliance program guidance documents and is currently seeking feedback from stakeholders regarding risk areas related to different types of providers and suppliers that they should address in industry-specific guidance. Among other traditional compliance topics in the general program guidance, the guidance addresses information blocking, which is engaging in conduct that's likely to interfere with, prevent, or materially discourage the access, exchange, or use of electronic health information, which is generally regulated by the Office of the National Coordinator for Health Information Technology. Another topic addressed by the guidance is investigations conducted by legal counsel. The guidance provides and recommends that the compliance officer should remain involved in healthcare compliance investigations in which counsel takes the lead. Despite this recommendation, manufacturers should exercise caution in how compliance officers participate in internal investigations that are run by legal counsel. Most of the activities undertaken by a compliance officer are not attorney-client privilege protected, and accordingly, the role of the compliance officer in conducting an internal investigation should be well defined as assisting legal counsel with the investigation. For example, attorney-client privilege protection may not be available for business advice provided by the compliance officer to management, for emails from the compliance officer updating management regarding the status of the investigation, or for standard compliance documents generated by the compliance officer, such as compliance logs, as those documents are generally not communications with an attorney for the purpose of obtaining legal advice. Accordingly, when conducting investigations internally at the direction of legal counsel, manufacturers should ensure that they carefully discuss the extent and role of the compliance officer in that investigation with supervising legal counsel to ensure that the privilege will be appropriately protected. On October 25th, the OIG posted an unfavorable advisory opinion regarding our cochlear implant manufacturer's proposal to offer and provide a free compatible hearing aid worth between approximately $1,200 to $2,200 to certain patients who received one of the company's cochlear implants. This case is relevant to medical device manufacturers as it reflects a value-added item that this manufacturer intended to provide to its customers and reflects another example of the OIG's disfavorable perspective regarding the provision of value-added items and services by life sciences companies, including medical device manufacturers. In this advisory opinion, the requester also proposed to potentially limit the free hearing aid to beneficiaries with income at or below 300% of the federal poverty level. The OIG concluded that the arrangement as proposed would generate prohibited remuneration under the federal anti-kickback statute, as well as under the beneficiary inducement prohibition, and that it would likely constitute grounds for the imposition of sanctions. The proposal included providing free, non-covered hearing aids to patients with moderate to severe hearing loss in one ear when they received a cochlear implant in the other ear, and made the provision of the free hearing aid contingent on the purchase of the cochlear implant. Patients and audiologists under the arrangement would have been prohibited from billing for the hearing aid, and audiologists would only have been permitted to charge the usual and customary charge for fitting the hearing aid. In analyzing the federal anti-kickback statute violation, the OIG took the position that the provision of the free hearing aid would likely constitute an unlawful inducement to the patient to select the manufacturer to receive the cochlear implant. The OIG reviewed the arrangement for compliance with the anti-kickback safe harbor for patient engagement and support to improve quality, health outcomes, and efficiency. This is one of the safe harbors that it would adopted in 2020 with the value-based enterprise safe harbors. And the OIG, when it adopted these safe harbors, expressly excluded medical device manufacturers from protection under the value-based enterprise safe harbors, except for a very narrow exception for providing digital health technology. DME POS suppliers were also excluded from protection under this safe harbor unless they primarily provided services. They determined in reaching the conclusion that the safe harbor was not applicable, that the value of the hearing aid, again, $1,200 to $2,200, exceeded the current $570 cap under the safe harbor. While not discussed by the OIG, even if the value was under $570, this value-based enterprise safe harbor would likely not be available and serve as a defense for the manufacturer because, again, the manufacturer was a DME POS supplier, likely not primarily in the business of providing services. And the medical device manufacturer was also excluded from protection under the safe harbor because the free hearing aid is not digital health technology. Accordingly, even if it was under 570, this safe harbor would likely not apply. Effectively, the Office of Inspector General concluded that providing the free hearing aid could inappropriately steer patients to receive the requester's cochlear implant over another company's implant in violation of the federal anti-kickback statute. The OIG also raised concerns that providing the free hearing aid might result in unfair competition with the requester's competitors, particularly that smaller competitors might not be able to afford to purchase and provide free hearing aid. It is important to note that the OIG did not analyze the free hearing aid under the statutory discount exception and did not analyze it under the discount safe harbor to the federal anti-kickback statute. In developing value-added and value-based models, it may be possible under the discount safe harbor to develop a product bundle where one product is provided for free or a substantial discount in exchange for providing the other product, depending on compliance with the safe harbor. Specifically, under the discount safe harbor, a discount does not include supplying one good or service without charge or at a reduced charge to induce the purchase of a different good or service unless, this is the requirements to comply with the safe harbor, the goods and services are reimbursed by the same federal healthcare program using the same methodology, and the reduced charge is fully disclosed to the federal healthcare program and accurately reflected where appropriate to the reimbursement methodology. Here, the hearing aid is a non-covered product because hearing aids are not covered by Medicare generally. But if the hearing aid had been reimbursable by Medicare in the same manner as the cochlear implant, it might have been possible to protect this arrangement under the discount safe harbor. Similarly, the statutory discount exception permits providing a discount or other reduction in price that is obtained by a provider or other entity under that provides federal healthcare program services if the reduction in price is properly disclosed and appropriately reflected in the cost claimed or charges made by the provider or the other entity under a federal healthcare program. It's unclear why the OIG did not analyze the provision of the free hearing aid under the discounts exception or under the discount safe harbor, but it may be the case that the OIG did not view the provision of the hearing aid effectively as legitimate because it was a separate device from the cochlear implant. It really had nothing to do with the implant that was being purchased, other than the fact that the patient also had diminished hearing in their other ear. The OIG also analyzed the proposal under the beneficiary inducement prohibition. which prohibits offering or providing something of value to a beneficiary that the person knows or should know is likely to influence that beneficiary to select a particular provider or supplier of items or services that may be reimbursable by Medicare or Medicaid. The OIG concluded that the hearing aid could cause a patient to select the requester, again, a Medicare-enrolled DME POS supplier, to provide the cochlear implant in violation of the beneficiary inducement prohibition. In reviewing the potential exceptions to the definition of remuneration under the BIP, the OIG determined that the exception for remuneration that promotes access to care and poses a low risk of harm to patients in the federal health care program, that exception was not applicable because the hearing aid would not improve the beneficiary's ability to obtain items and services payable by Medicare and Medicaid. Specifically, that exception to the definition of remuneration only is to improve access to covered items and services, and the OIG's position is that the hearing aid is not a covered item, and therefore providing it for free did not improve the beneficiary's ability to obtain access to items and services covered by Medicare and Medicaid. The OIG also reviewed the financial need-based exception to the beneficiary inducement prohibition, but concluded that that exception could not be satisfied, even if the hearing aid was only provided to patients with income at or below 300% of the federal poverty level, because the hearing aid was expressly conditioned on the purchase of the cochlear implant, and that exception to the definition of remuneration prohibits the free item or service from being tied to a covered item or service. So accordingly, neither of those exceptions to the beneficiary inducement prohibition were applicable. This opinion parallels the OIG's historical view regarding value-added items and services. The OIG's position has historically been that value-added items and services that have a value separate and apart from the purchased product raise fraud and abuse concerns because they have independent value to a customer or a patient, and therefore may induce or reward the patient or a customer to purchase the company's product. As you may know, there's been a mixed history of OIG reviewing value-added items and services that are provided by manufacturers to customers and patients. Sometimes advisory opinions determine that the free item or service may be provided. In other circumstances, they conclude that it would raise concerns under the AKS, under the BIP, and other fraud and abuse laws. One of the distinguishing factors that the OIG focuses on in reviewing these types of value-added arrangements, again, is whether the item has independent value to the customer or whether there is no difference in separation from the value that that item provides as compared to the product that was purchased. One of the originating cases involving value-added items was the provision of a computer for a provider to order laboratory services through the computer. And the determinative issue in that case was whether the computer could be used for other activities and therefore represent independent value to the provider, or whether the computer was locked down and could only be used as a portal for the provider to order laboratory services. In this case, the hearing aid was separate from and had a well-established value, independent and separate from the cochlear implant. There was no combination product here. The hearing aid was actually purchased separately and had nothing to do with the cochlear implant would go in the other ear. Moreover, the value of the free hearing aid far exceeded the amounts allowable under the potential applicable safe harbors to the anti-kickback statute as well as to the beneficiary inducement prohibition, and was clearly tied to the purchase of the cochlear implant. With the increasing adoption of value-based care models, many manufacturers have been considering providing and have gone forward and provided certain value-added items and services to their customers. However, any such value-added items and services have to be carefully reviewed for compliance with fraud and abuse laws, including under the federal anti-kickback statute and the beneficiary inducement prohibition, particularly in light of the fact that there are generally no safe harbors available as a defense for the provision of value-added items and services to manufacturers due largely to the OIG's exclusion of manufacturers from protection of the value-based enterprise safe harbors. As I mentioned before, it may be possible to protect some types of value-added items in a product bundle, but those arrangements have to be individually analyzed for compliance with the applicable safe harbor in light of the OIG's historical guidance. The challenge here, unfortunately, is that the OIG has not provided clear guidance regarding the scope of permissible value-added items and services, and largely, as I mentioned, excluded manufacturers from protection under the relevant safe harbors. Instead, the OIG, in adopting the value-based enterprise safe harbors that otherwise would protect these types of items, or might, the OIG indicated that manufacturers should utilize the advisory opinion process to determine whether an arrangement is permissible under applicable fraud and abuse laws. However, as reflected in this advisory opinion, the OIG remains very skeptical of life sciences companies, and accordingly, manufacturers should exercise significant caution in developing value-added and value-based models for their customers. AdvaMed earlier this year had submitted a proposed safe harbor to OIG for consideration to include manufacturers, in particular medical device manufacturers, under the value-based enterprise safe harbors, as well as to adopt additional safe harbors related to value-based and value-added models. It's unclear whether the OIG will actually adopt a safe harbor that protects the life sciences industry and provides clear guidance on value-based and value-added models due to the OIG's historical skepticism of the life sciences industry. However, we remain hopeful that the OIG will come out with some clear guidance as opposed to requiring a detailed analysis based effectively on the OIG's historical pronouncements and on the purpose of the provision of the free item in the service. I think that the OIG just has a difference of opinion with the life sciences industry, and the life sciences industry perspective is that many of these models are intended to improve outcomes and improve care for patients. And the OIG's perspective is many of these models really are intended to provide perks to customers to induce them to purchase products, and maybe in addition to improving outcomes, but with the primary purpose of driving purchases. And the OIG has yet to relent and provide clear guidance other than in its advisory opinions regarding the types of value-based models that may be permissible. Another challenge is that advisory opinions can only be relied upon by the requester, and accordingly, despite the OIG having issued a historical advisory opinion permitting a particular value-based or value-added model, medical device manufacturers have to exercise caution in relying on those opinions because, as a technical matter, you cannot use those advisory opinions as a defense in a DOJ prosecution. Accordingly, this area is still complex and mired in uncertainty, and typically medical device manufacturers should engage legal counsel to develop any value-based or value-added models before going to market with them, or otherwise seek an advisory opinion from the OIG. On November 3rd, the FDA issued guidance regarding its enforcement policy for clinical electronic thermometers at the conclusion of the COVID-19 public health emergency. The FDA is proposing to exempt clinical electronic thermometers without telethermography or continuous temperature measurement functions from pre-market notification requirements. As you're aware, FDA guidance documents do not generally establish legally enforceable responsibilities unless specific regulatory or statutory requirements are cited, but rather if and when finalized, instead describe the agency's current thinking on a topic and should primarily be reviewed as recommendations. Also on November 3rd, the FDA released updated guidance regarding the process to request a review of a decision of the FDA not to issue expert certificates for devices. On November 2nd, the FDA issued updated guidance regarding its enforcement policy for certain supplements for approved pre-market approval or humanitarian device exempt submissions. Under the guidance, the FDA does not intend to object to limited modifications to the manufacturing of devices approved through the PMA or HDE programs without prior submission of the required PMA or HDE supplement or 30-day notice, where the modification is necessary to address current manufacturing limitations, potential shortages, or supply chain issues. The policy also addresses and applies to limited modifications to address current manufacturing limitations, potential shortages, or supply chain issues that result in changes to the performance or design specifications, circuits, components, ingredients, or physical layout of a device that would otherwise trigger the requirement to submit a 180-day or real-time PMA supplement or a 75-day HDE supplement. Manufacturers are still required to verify that any changes do not negatively affect the safety or the performance of the device. In lieu of prior submission of a required PMA or HDE supplement, FDA does not intend to object to the implementation of these modifications if manufacturers include a retrospective update in their next periodic report. However, the guidance addresses certain changes that are outside the scope of this policy, which include changes to the intended use or new indications for use, labeling changes outside the scope of certain types of changes referenced in the guidance, changes to sterility assurance levels or sterility and sterilization methods, changes to reduce or eliminate quality control testing, automation of a manufacturing process that's not fully verified, and a change in the defect's device performance, but is not caused by a component unavailability. Originally, these flexibilities were only intended to last for 180 days after the end of the COVID-19 public health emergency, but the FDA intends to extend these flexibilities indefinitely. On October 24th, the FDA updated its FAQ draft guidance regarding communications to healthcare providers regarding scientific information on unapproved uses, SIUU, for approved or cleared medical products. The guidance addresses sharing reprints, published clinical reference resources, and firm-generated presentations of scientific information that are taken from published reprints and sharing those documents with healthcare providers. Such communications must be truthful, non-misleading, factual, unbiased, and provide all information necessary for healthcare providers to interpret the strengths and weaknesses, the validity and utility of those presented information. All studies and analyses that serve as a basis for such communications must be scientifically sound. The FDA does not intend to use SIUU communications with healthcare providers that are consistent with the guidance, standing alone as evidence of a new intended use for a product. The questions addressed by the guidance include what firms should consider when determining if source publications can serve as a basis for SIUU communications, the types of information firms should include in SIUU communications, the considerations firms should address when making presentations of SIUU, and the recommendations regarding certain types of SIUU communications. Manufacturers should carefully review this guidance to understand the FDA's current thinking on SIUU. We've frequently seen manufacturers at significant risk to themselves seek to use study data from uncontrolled or small studies to support potential unapproved or uncleared uses. And it's very important that manufacturers review and understand the FDA's current thinking on the level, size, and scope of data that is necessary to support SIUU when provided by manufacturers to customers. This guidance document provides good insight regarding the type of data that the FDA expects manufacturers to have in order to support SIUU communications, and to the extent manufacturers intend to develop and provide SIUU communications to healthcare providers, they should carefully review the source and data and the layout and formatting and the manner in which they provide SIUU communication for compliance with this guidance document. Thank you for joining me this week for Medical Device Legal News. I'm Sam Bernstein, a partner of McGuire Healthcare Group. I would also like to thank my colleague, Sophie Morals, for helping to make today's program possible. I look forward to speaking with you next time.